Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book on Estoppel, which is a wonderful subject and something. Now don't go and run out of the room immediately you hear this, because this is an important area. This book is Estoppel by Conduct and Election. It's been written by K R Handley, who's a judge from New Zealand. It's now in a second edition. It's come to us from Sweet Maxwell, THOMSON, REUTERS, and it's a very important book, and I'll explain why in a minute. Now, Elizabeth and I talked about this book because the doctrine of Estoppel, if I can call it that, is not something that people sometimes understand. It's difficult to teach, as I have found. People do sometimes have a confusion. In the courts, it's even worse, because some people have absolutely no idea what we're talking about, and they don't seem to understand that Estoppel is actually, it's equitable, but it's very wide concepts involved. Obviously the equitable element, which is discretion, is far more important in my submission than the common law part of it. However, it's an important aspect of what we do in terms of general legal principles. Right at the beginning of any form of training, you've got to understand when someone is estopped and what that means and what the words mean, because we are talking about words and they're confusing. Now, we've given the title of this book A Brilliant Explanation of Estoppel in the Modern Context, and that's exactly what Handley has done. Now, before we start, let me show it. It's a small book, it's hardback, Sweet Maxwell, very nice cover. It's the Contract Law Library. And there's the book itself, nothing on the back. The book itself, it runs to 350 odd pages. There's the index right at the back there. Quite a lot of information, very much the house style of Sweet and Maxwell. What you've got, of course, is paragraph numbering at the sides, and you've got useful footnoting at the bottom to justify all of the statements made. A lot of case law being referred to, of course, here. It's a very erudite book, which is to be expected. The Honourable K R Handley has produced a lot of information, and that is the information that you want to start off with, the foreword, which sets out what has actually been happening. Now, Professor Hayden has actually written the foreword. Many of you will know him from the past, and then the preface to the second edition by Handley is written, dated the December the 20th, 2015, and it's quite detailed. This is not, I didn't find this the easiest book to read, I have to say, but I did think it was an important book. There's the preface to the first edition, which is also set out, which goes back 10 years to 2006. Then you've got the contents section setting out common law estoppel, equitable estoppel, so forth, the various chapter headings running all the way through, which you can see there. Again, elections we get on to, and then right at the end you get estoppels and election proceedings, affirmative answers, practice, and so forth, and table of cases, and they're structured by country. So we start off with the UK. There are a lot of cases covering a whole range of different jurisdictions: Ireland, Northern Ireland, and so on. Australia, of course, New Zealand. I believe Mr. Handley is New Zealand, but I may be wrong. It may be Australia, but certainly Australasia, if I can put it that way. The abbreviations are very helpful indeed. This is a good book, by the way, and very detailed. You can see, and also global. That's another thing which I think is important, because it is important for any common law jurisdiction. It starts off, introduction, common law estoppel. Estop is an Old English word derived from the French, which means stop, which with its substantive estoppel has acquired a technical legal meaning. And we go back to Cook, or Coke, I call him Cook. Cook said there are three kinds of estoppel: by matter of record, by matter in writing, and by matter in pays. Now, what do we mean by pays? That's an interesting one. Again, res judicature, res judicata estoppel is very, very important, because the point about it, this is a fundamental point for anybody just starting, is once you've got finality in a judgment, you can't still come back again and want more. In other words, you have to draw a line eventually and be stopped or estopped from pursuing further matters when in fact a decision has been made. And one of the problems you get with clients, and it's worse now with litigants in person, is they don't take no for an answer and they will come back wanting more, and that's when the problems really start, because the concept of estoppel is to draw a line, effectively, if I can put it that way. It's to draw a line under things, say, right, that's as far as you go. You're prevented from doing anything further. Let me expand on that, because I'm trying to make what is actually a very complex and a difficult subject to teach, certainly. I'm trying to make it relevant, perhaps, for practicing barristers. The reason I say that is because estoppel does crop up on quite a regular basis in your cases, and you can suddenly find that you will be stopped or prevented from doing certain thing, in other words, are stopped. And then you'll find the other side hasn't got a clue what you're talking about. And that's really why the judge certainly will, I hope. But I mean, the fact is that you do need to understand where it's a mechanism, if you like, can be brought in. So this is what we say. Estoppel, as a concept, is a bit of a Protean monster, reminding us of old Proteus, the Greek deity, who could change shape at will. If proof were needed, this quite engrossing book, now in a new edition from Sweet and Maxwell and THOMSON REUTERS, clearly reveals that yes, estoppel is a bit of a shape shifter. Over at least the past couple of 100 years, estoppel has assumed many different forms under a number of different names, depending on the circumstances of each case, and I indicated Cook's remarks from many centuries ago. It is nothing if not adoptive more to the bafflement of generations of law students, not to mention more than a few fully fledged lawyers. And in fact, I think this bafflement is a problem, because sometimes they hear the word estoppel and sort of the face goes a bit white. People think, oh, that's a new one that's been thrown into the mix. Well, you can understand the concerns, but don't be afraid, because things like this book will help you. Even the definition of estoppel remains, of course, elusive, and as the author K R Handley says, and he's built up a formidable reputation worldwide as a legal scholar, he explains that the term derives from the Old English word estop, which in turn derives from the French meaning stop, and he starts that off right at the beginning, so we know clearly where we are. So it is a stop, and estoppel, stop, not too difficult. Sometimes it's referred to as finality, and that's really what I said a little earlier again, because it's the finality of a judgment. You've got to be stopped after a while from continually raking over the old coals, if I can use that expression. In other words, you've got to have some concepts that are brought in to say, well, that's enough, enough's enough. So estoppel is, of course, defined in law dictionaries, in which the definition or definitions can be hundreds of lines long. Just have to look at Jowett or Stroud and you'll see it's a very substantial area where you have to build it up to explain how estoppel works. Now, as the author explains, estoppel has acquired a technical legal meaning. His introduction to this book provides a useful overview of the many manifestations of the term, including instances where its principles are adhered to without the term estoppel being mentioned at all. So in fact you are estopped, but you know you've been estopped, if you understand me. So by way of a close analysis, expert commentary and frequent reference to cases across a range of mainly common law jurisdictions, Handley goes on to explore in the body of this text the multiplicity of ways and means by which estoppel may be and has been interpreted or applied. And that's really the beauty of the book. To cite only one example of certain conflicting views regarding estoppel, it's interesting to know Lord Wright's comment early in the 20th century that estoppel is a complex legal notion involving a combination of several essential elements, often described as a rule of evidence. The whole concept is more correctly viewed as a substantive rule of law, and that really is what it is. I call it a doctrine, but in fact it is a substantive rule of law itself. So we go forward to the 1970s and note Denning's comments in Moorgate that estoppel is not a rule of evidence. It's not a cause of action, it's a principle of justice and equity. Well, Denning would say that, wouldn't he? And I think he's right, personally. I know that some academics would not agree with him, and certain law lords wouldn't, but I think he's right. There are many in the legal profession who would agree, as I say then, with Denning, who regarded Estoppel as a useful device in the procurement of justice for the disadvantaged. That is one interpretation. The meek who should inherit the earth, but who often don't. Now, the point I'm making there is that he did try to use it to make sure he got the right result. Whether that's right or wrong, I don't know. Hence the view that it considered to be a little unorthodox. However, I think that that's an important point to bear in mind, because he tried to push the boundaries of Estoppel as far as it would go until it restricted a bit. Now, the new edition then, this is the second edition of this scholarly and extensively researched work of reference, reflects the many new developments in this area of law that have emerged in the past 10 years since the first edition was published. And as the author has included material not only from England and Wales, but from Canada, Australia, Hong Kong, Malaysia, New Zealand and Singapore, and both jurisdictions and Ireland, it's certainly the book that will be of abiding interest to international lawyers. Let me conclude by saying that, considering the complexity of Estoppel, it's reassuring to know that this book is logically organised, with numbered paragraphs throughout, which I've shown you, extensive footnoting, plus the tables of cases and statutes. And typical of the legal text from Sweet and Maxwell, it provides a lengthy and detailed table of contents and index at the back, much in their house style. So we think counsel or judges, or for the matter students, and I think students certainly, basically undergraduates, might find this helpful too, needing to confront the subjects will find this book good, because they're doubtless regarded as a book which is essential reading. Now, the publication date is cited at December 2015. Let's have a quick look at it again. Nice green cover. There we go. It's a light book, it's not heavy. It's the Contract Law Library for Sweet and Maxwell. Again, it's a nice hardback book. As I say, it's not the easiest book to read. But for instance, just opening it here, acquiescence as equitable defence. You can see immediately what Handley is doing is he's actually bringing in the case law very quickly, because this is really about case law more than anything else. Because eventually, as I indicated earlier, I think it's far more important in the equitable jurisdiction, where you have a discretion, because you can then use it. And I'm sure that is exactly what many judges would like to do. Do have a look at the preface to the second edition, which he's written, which sets out some of the changes and why he's brought in a few other things. He does refer to other publications as well. But I'm generally very pleased. You can see with this book, you can see there's a lot of footnoting, which is to give you the basic detail should you need to go on further. It's, as I say, Estoppel is not the easiest concept. I know I had problems with it when I was student. It does crop up more than often than you think in practice, and I think this book does go a long way to help you. So thank you to all concerned for an excellent publication. Bye bye.